No mai, haere mai. Welcome to this ordinary meeting of Nelson City Council. I'll ask you to all stand for the opening prayer.
Almighty God, sovereign in all things, bless this city and its people. Guide us in local government each day, that our decisions may be wise and just, and magnify your holy name. Amen.
Amen. Good morning, Council. Hatamarie, welcome. We're here today to deliberate on our draft city amenity bylaw. You have an agenda that has been distributed to you last week. You also have some additional documents that have been distributed this morning, including a late item, which is receipt of the minutes for the meeting of the 22nd of June. And I'm going to talk you through those documents in just a moment. The first things that I would like to cover off relate to apologies. Do we have any apologies? Does anybody need to leave at any point today, this morning? Councillor Laurie.
I'll have to go at 1:45 midday.
Thank you. Anybody else? All right, thank you. We'll note that. Confirmation of order of business will be as set out on the agenda sheet, but noting that we have a late item to address and some documents to talk you through. We will be live streaming as normal, so I do encourage you to use your microphones and please turn them off when you're finished. We have a late item, as I said, that has been tabled, which are the minutes of the hearing of submissions. They're dated the 22nd of June, and there is a recommend that we consider this as a late item, so the recommendation is there. Some of you may wish to have some time to read those minutes, and I'm happy to take a recess so you can do that. But what I would like us to now move the recommendation, which I'm going to do, to receive these as a late item. So I'm moving that recommendation. It's been seconded by Councillor Dalberg. Thank you. Are there any questions on the motion? In that case, I'll put the motion. All those in favour? Aye. Against? Carried. So we now have the minutes that have been received in today, so as good practice, and the administration advisors have apologised for the fact that due to a procedural error they didn't come through. For those of you who are councillors, you know that the organisation has been under considerable pressure, like many organisations around Nelson, with the very bad virus that is circulating, and we have had a significant number of staff who have been away. So I accept that sometimes these things happen when we're very understaffed with illness. The interest register, are there any interests that councillors wish to note at this point in relation to the matters that we need to discuss today? No, thank you. In that case, what we've got today, just talking through the documents, you have tabled some feedback. The first item is a document from Michelle Maxted, and that is from here in the city. Now, we had a meeting with retailers Monday week ago, and at that meeting this document was passed to the Acting Chief Executive, myself, and there was a request that we circulate that, but it came through, I think, yesterday just in terms of an email, so we've done that and fulfilled our commitment that we would do that. You also have tabled an amended recommendation from the officers. I've had a chance to talk through that recommendation with Ms. Barton, and I am satisfied that that is a sound recommendation, and I wish to move that recommendation. So I've had an opportunity to look at that. I know you will want to read through that in the documents, so what I'm going to propose is, if you would like, I can take a recess to allow you to do that for a few minutes, or alternatively I can ask Ms. Barton to come to the table to talk you through that. She has prepared her rationale for what is here. So if you're happy for her to talk you through that, we'll just go into that. And so if someone's had an opportunity to look at this and they're happy to second it now, I'll take a seconder, so we're starting from a position, and I'm very happy to do that if it feels right. Otherwise I can wait for that. Councillor Rutledge is happy to second it. All right, so we're moving what has been tabled, and that has been seconded, and I'll invite Ms. Barton to come to the table, who will talk us through this. For the benefit of the public gallery, what I'm proposing that we do today is that we have an updated recommendation from Ms. Barton. She's going to talk us through that. She's going to run through the report that is part of the agenda and the steps that have been looked at in developing her recommendation today. Then we're going to invite Ms. Julian to the table, who's going to talk through the bylaw itself and the clauses so councillors can see what is in there. And what has been signalled to me prior to the meeting is that councillors wish to ask legal questions and receive answers to those questions, which will mean that we will need to go into public excluded. And so what I will do is I will take that opportunity for Ms. Anderson to be able to answer those legal questions. We will do that in public excluded, which is our normal practice, and important that we do that to ensure good process. And so, councillors, if you have legal questions, I'll ask you to hold those until we get to the point where we're going to have an opportunity to question and answer with Ms. Anderson. Now, as there's a reasonably full public gallery today, rather than ask you to all try and go out and squeeze into the foyer, which can be rather awkward and there's nowhere to sit down, what I may propose is that you stay here and we will adjourn to another room so that we can receive that advice, just for your comfort. Any questions in terms of that process? I think that's reasonably clear, councillors. So I'll invite Ms. Barton to address the council. Good morning.
Good morning, Madam Mayor and councillors. The tabled item that you have with some yellow highlighting on it, I'm proposing to run through the changes that I am now proposing. So I will start with the last one first, only because it makes sense from my end. So if you turn over the page, and there is a strike through in the last recommendation about agreeing that the Chief Executive can make minor amendments to the bylaw. And I've recommended that that's removed because it was proposed in the first place to allow minor changes. So for example, putting the date that the bylaw commences within the bylaw itself. That is now part of the consideration that you've got before you, because it is a recommendation that's included in the sheet. And so from that point of view, it's not considered necessary. And in addition, section 1562 of the Local Government Act does allow for minor amendments to be made, so we didn't think that that was necessary. In terms of, so turning back to the first page, the changes that are proposed to the 4th and the 6th recommendations are essentially the same, and I'll just walk you through the reasoning for that. So my role here today is to give you the best possible advice that I can, and to that end I've considered the problem definition that was put forward as part of the bylaw process and that is reported on in my report. And I consider that it's appropriate that the bylaw as drafted in attachment 1, which includes the sleeping provisions, is the one that I'm recommending to go through today. And in making that, I have set out the reasons why the sleeping provisions in particular should be retained at paragraph 5.23 of my report. And I'd also just like to highlight that since drafting the report, we've also looked at other bylaws specifically around sleeping around the country. And there are a number of other councils that have similar provisions, and I'm just going to highlight 3 of them today. So in particular, Pororoa City Council has a bylaw called a Public Places Bylaw. It prevents camping in places that are not set aside for that purpose. And camping is defined broadly as living, residing, temporarily or permanently. So that's the definition. In relation to Napier City Council, they too have a public places bylaw that states that it is an offence to occupy a public place without a permit. And the other example that I want to highlight is that Hamilton City has a bylaw which deals with nuisance, and it includes sleeping in a public place. So that is called their Safety in Public Places bylaw. That is the change that I'm proposing by deleting the reference to all those shown in attachment 1A. So attachment 1A is the bylaw that deletes or proposes to delete the sleeping clause. So my recommendation is that we proceed on the basis of attachment 1, which includes that provision. The other changes that I'm proposing in those recommendations are that you'll note it says without clause 13.2. Clause 13.2 in attachment 1 was an option of defining the area that the sleeping provisions apply to the inner city, rather than the city centres, which were defined in the bylaw as notified. And I'm recommending that it be applied to the city centres, which are defined and included in the maps in the attachment. And the third change that I've identified there is in relation to the definition of sleep. So on closer analysis, some of which was last evening, so I apologise for not getting this to you earlier, there is a slight inconsistency between the clause 13.1 around sleeping and the definition for sleep. So I'm proposing to make those consistent, and the wording that's underlined is looking to make those two provisions consistent with each other. So it would apply to the footpath or the road in the city centres. And I think that summarises why I have put those changes to the recommendations forward.
All right, thank you, Ms. Bowden. Do you want to now move on to talking us through your report?
So through you, Madam Mayor, yes, I can do that.
Thank you.
So what I'm proposing to do is walk us through the report. I'm not proposing to read out verbatim the content of the report, but there are some particular provisions that I wish to highlight. In particular, the matters that are particularly germane to your decision today. So if I turn you now to page 4 of the report, which contains the summary, I'd like to just confirm that the role today of the Council is to look at the City Amenity Bylaw and ensure it's consistent with the New Zealand Bill of Rights Act, determine that the bylaw is the most appropriate form of bylaw, and a decision about either adopting the bylaw in whole or in part with amendments, or withdrawing the bylaw, determining that any amendments to the bylaw are within the scope of submissions, and setting out the reasons for any decisions, and I'll come back to that at the end. So the recommendation, as you've seen, is that the provisions of the bylaw be changed to the extent that are shown in attachment 1, and in particular, and Ms. Julian's going to run you through the specifics of this, but in particular that clause 12, events and permits, is changed to a notification process, and that clause 13 is amended to the extent that it now aligns up with the definition of sleep, and there are a number of other minor amendments that Ms. Julian will run you through. So if I can now turn you please to page 5.7, paragraph 5.7, page 10. There's one provision I just wish to highlight because it was a matter that was raised through submission, and it's something that I wish to acknowledge. So paragraph 5.7a noted that in advice that was previously given to Council, that the provisions of the bylaw as notified were in accordance with the Wellington City Council's bylaw process. That was on the basis of the advice provided on their internet, on their website, and subsequent investigation found that the website was inconsistent with how they were applying the bylaw. Hence my recommendation that the permit provisions be amended to now line up with where Wellington City have got to, which is around a notification process. So page 11, I'd just like to bring your attention to the problem definition, because that's a key part of the decision making today. And at paragraph 5.10, I've highlighted what the Council has articulated around the perceived problems, and that they are amenity in the city centres is being affected by others' use of it, that public use of the footpath is being obstructed, including the ability in particular to view shop frontages. Safety and the perception of safety of pedestrians and traffic is being impacted by others' use. There's some issues concerning safety of those at night time, and also the potential for protests to affect others that are using public places. I'll then turn you to the consideration of the New Zealand Bill of Rights Act, which is on page 13. And paragraph 5.15, I've identified relevant case law, and in particular the courts have accepted that the freedoms enshrined in the Bill of Rights Act may be limited by a bylaw if the objective for that bylaw is, and I'll read those 4 points out, pressing and substantial and sufficient to override the protected right of freedom. There is a rational connection between the limitation proposed by the bylaw and the stated objective of the bylaw that is not arbitrary, unfair, or based on irrational considerations. The right or freedom is impaired as little as reasonably possible, and the bylaw limitation is a proportional response to the problem. So at paragraph 5.17, I note that it's considered the notified bylaw as currently drafted met the requirements of New Zealand BORA with the exception of clause 12, hence the recommended change to the permit provisions. So at paragraph 5.21, I just identify what those proposed changes are to clause 12, which is the permit process, and that is that it be amended so that if there would be if there's likely to be an event that may impede public safety and access, that there be a simple notification process to council of that event. I also want to highlight the provisions in paragraph 5.23, which deal with the sleeping changes that I highlighted earlier, and in particular in relation to the New Zealand Bill of Rights Act. So I consider that there is a rational connection between the limitation and the objective of ensuring a safe environment for all people, that the area the bylaw relates to is geographically limited, and it's limited even further to the footpaths and roads within that area, and it's not disproportionate and does not unduly restrict people's freedoms. And also at paragraph C, under paragraph 5.23, where a person is homeless and not protesting, council's first response will be engagement with the appropriate social services to try and find alternative accommodation for those people. And I've reflected that in the recommendations that I've put forward today. I'd now like to highlight the provisions on page 17 of the report. Thank you. And what I have set out there are the reasons that I believe that need to be considered, but that is something that council needs to turn their mind to and confirm whether there are any additional reasons, amended reasons, or changes that might be required to the reasons that are set out in the report. So paragraphs 7.4 through to 7.8 identify what I consider to be the reasons, but this is council's decision, so there needs to be confirmation of those. And just in summary, the perceived problems identified, I'm still hanging on to a bit of my cold. So the perceived problems identified before commencing the bylaw remain, and the council still considers that the bylaw is the most appropriate way of addressing those problems. The council's considered all of the submissions that have been received, and the changes to the bylaw reflect the content of those submissions. That in particular the Council has carefully considered the issues raised in submissions with regard to the New Zealand Bill of Rights Act, and that with the changes that are proposed, the relevant tests are met. That the Council has determined that the bylaw as amended will achieve the objective of regulating the use of public places so that it can be used and enjoyed by all. And finally, that the Council considers that the amended bylaw as contained in Attachment 1 is the most appropriate form of bylaw, and it is a reasonable solution to the problems identified. And in final summary, I just want to note that the bylaw, we're satisfied that the bylaw as contained in Attachment 1 meets all the relevant tests, and in particular we've addressed the issue around the New Zealand Bill of Rights Act. Careful consideration has been given to the submissions that have been received, and the changes to the bylaw are consistent with those provisions that have been raised in submissions. So thank you. More than happy to answer any questions.
Thank you, Ms. Bowden. I just want to check that the amended attachment has been distributed to councillors. I understand the recommendation has been. Do they also have the amended bylaw?
So Attachment 1, which is the amended bylaw, as I'm recommending,
Yes.
is as set out in the attachment, subject to the two changes that are reflected in the changed recommendation, which is that clause 13.2 be deleted, and that the definition of sleep be amended.
All right. And I think it would be useful if we could just have, as we go through, exactly what those the amendment looks like. I think that would be useful for the councillors so they understand what it is. When they're looking at their pages, they can then strike out. So they should strike out 13, all of 13. So if they're working off Attachment 1.
So if they're working off Attachment 1, the strikeout is clause 13.2.
13.2, thank you. So that is removed. So that's the very last one.
Yes.
On page, what is on my page
On
12?
page, yes.
Right, thank you. 32 of the agenda.
And
So page
then
32.
the other change is in relation to the definition of sleep.
Of sleep or sleeping, will it
I
be
think
now?
we ended up with sleep. I think that's a strike
All right,
through
so
for
we'll
Ing.
need to just see those words, so someone will need to be able to pop those on the screen or have them to be able to distribute. And EJ, the page number on the agenda for the definition, just because I'm working on page 26. All right, so as we go through that with Miss Julian, she can run us through those particular steps. So Council, I'm happy to take questions now for Ms. Barton, but you may still be forming your questions, and it may be useful for you to hear from Ms. Julian just to get the whole sweep. But if there are any initial questions, I'll take those now. Councillor Laurie.
Thank you, Madam Mayor, and thank you, Ms. Barton. I'm really pleased to see the permit to protest part taken out of the bylaw. Can you tell us why it was taken out, please?
So through you, Madam Mayor, when the bylaw was proposed, it was understood that it was in accordance with what Wellington City had, their approach that they had taken. As I highlighted in identifying my report, the bits of my report, subsequent advice received was it wasn't consistent, and on that basis it's now proposed to be amended. To be in accordance.
Removed. Yeah.
To be changed to a notification process.
Okay, so next question on the notification part, on 5.22, speaking about the notification, it says deleting the clause as an alternative. Deletion would mean there is no foreknowledge of an organised event, which would put council officers on the back foot if things need to be arranged to assist the event. Now, at the moment, protests or events don't have to notify the council of what's being planned. But my understanding through the chair is that in most cases where traffic is going to be interrupted, for example, the organisers do tell the council or the police. Is that right?
So through you, Madam Mayor, there is a general approach that's made by the public to notify us where they require roads to be closed, and certainly that is an ongoing situation that people do advise us. But currently there is nothing that would require them or encourage them to do that notification. So there would be situations that could potentially occur where there would be no notice.
Potentially, through the chair. So my concern is we're creating a law to fix a problem that currently doesn't exist. What are your thoughts on that?
So through you, Madam Mayor, it was one of the problems that was identified. It was in particular about not impeding access for people, and this is one mechanism to ensure that that access is not impeded, because we would then receive notice of the potential for that to occur.
And through the chair, what would the penalty be for not notifying?
So through you, Madam Mayor, in this situation, while there might be a breach of it, it is only a notification process. It's not a formal permit process. So there would be a conversation that would be had with the organiser.
So through the chair, we can't actually enforce it.
So through you, Madam Mayor, if the council were of a mind to go to the nth degree around enforcement on that particular thing, there are options available. But as we've said right throughout, the first step that's taken around enforcement is to have a conversation with those individuals.
Thank you. Any further questions at this stage, or are you happy to wait to hear from Ms. Julian?
I have some more, if that's okay, Madam Mayor.
You have some more questions,
I have some more
Councillor?
questions, yeah.
Well, I'll just check. You've just had a string of them, so I just
Yep.
want to make sure, in fairness to others, so just so I know how I'm managing the meeting. So, all right, so you want to ask some more in relation to this report?
Yes.
And then when Councillor Laurie is finished with his questions, then we'll invite Ms. Julian to join the meeting. Councillor Laurie.
Thank you, Madam Mayor. So through the chair, the report says that where people are found to be sleeping in the CBD, enforcement officers will help them to find alternative arrangements. How will they do that, and where will they take these people?
So through you, Madam Mayor, while the ultimate enforcement would fall to the enforcement officers, there are conversations that have already commenced with social agencies about housing for those that unfortunately find themselves homeless, and those conversations will continue at a level that includes the Chief Executive, so that we can find alternative accommodation for those that require it.
So through the chair, homelessness is an increasing problem in New Zealand. Do we have the actual social services and the places for the current people that we've got living in the street, and do we have the capacity for potentially the future people we're going to have living on the street?
Councillor Laurie, I was going to update all of council just in terms of that aspect, so I'll do that now, because I think it'll help set your mind
Sure.
at rest. I've had a discussion with the Acting Chief Executive several weeks ago as we came through the bylaw process, and we discussed the issue of homelessness, and Mr. Hammond and I have been working on the approach of a mayoral summit on homelessness in Nelson and drawing together the stakeholders, sharing knowledge and expertise. We've looked at other examples around the country where councils work alongside agencies, and we're looking at how we explore that option and that response. At the outset, the approach is to understand the issue, and I will hand over to Mr. Hammond in a moment, but one thing we would say is that we are looking at a broader issue here. So one of the issues is bylaws are one of the things that councils do, but the other thing is that councils engage on a range of issues in their community. Several of you know that I've talked to you before about my concerns around methamphetamines and our role as mayors across New Zealand, and I've talked to you about the mayors of New Zealand are concerned on that issue. Equally, we're concerned on the issue of homelessness. So what Mr. Hammond has done already is he has already drawn the agencies together. He's had a very productive meeting already. We're at a scoping stage. The response was overwhelmingly positive from all of the agencies, very keen to engage, because I do believe that we have a role to play always as mayors, as councils, in leading on the issues that are important to our community. So I just hand over to Mr. Hammond and he can update you on how things are going.
Yes, through you, Your Worship. I met with a number of agencies, including MSD, DHB, Salvation Army and police, who are very keen to continue an ongoing dialogue particularly around the broader aspect of homelessness on the streets. It was really interesting to just get some sense of the scale of the issue, which actually nobody knows from the agencies, but estimate could be around about 100 people in Nelson. And there are various circumstances and various issues really in their lives. There has been quite an active process with MSD in the placement of people into various accommodations around Nelson, which has to be a mutual process of choice by the people they're placing as well. And that sometimes can create some issues, and it can also create issues when people are evicted from those accommodations as well, and need to submit themselves really to mental health assessments in order to be back into that type of assistance, and some choose not to do so. There is a broader need in the future for housing, and particularly for singles. It's much easier for the agencies to be placing family units than it is for single men and single women, and that does pose an issue to them. And there is some discussion about the concentration, I guess, of people into certain sites or locations or motels or boarding houses, or however you might like to express that accommodation, and discussion amongst the agencies about how most efficiently to do that and what's best for the city in the way that they do those placements. Broadly, we are going to continue to meet as a collective and scope this further, and particularly looking at some of the very successful models around New Zealand that are working quite well. One of those being the WISE project in Hamilton City, of which the agencies in a collaborative approach are meeting together. And I'm told by those I met with that they have achieved no people living on the street in Hamilton. I guess that's possibly hard to measure, but that seems to be the outcome that has been achieved in the Hamilton area. They also say, interestingly, that collaboration supported a bylaw developed by Hamilton City as being a necessary part of that whole equation. The other issue, so we're going to bring speakers up here to discuss that program and what we can learn from it in down here. Where am I? Yeah, I'm still in Coromandel. The other matter is the other program that's working quite well, and I think that does come from Christchurch, so it's down there, is a social investment board, and it's another approach which targets good wraparound services to families at an early stage rather than waiting for the issues to emerge on the other end of that. So I guess the overall message is that we recognise as a city that it's in nobody's best interest for their health, safety or well-being to be living on the street, whether that be by choice or by circumstance. And that's a statement that has got broad support across all of the agencies, and we discovered in conversation there is a lot that we can collaborate to do together and want to do so.
We're just not quite finished. I know this is obviously a subject that many of us feel very strongly about. But I think what we're dealing with today is our bylaw, and what Mr. Hammond is saying is that we're looking at a broader approach as well. And I think that's something that I know certainly is, in terms of my philosophy, homelessness in any form for any reason is not the best outcome for any Nelson citizen's health or safety or wider well-being. And I think we do have a role to work as the glue. It's part of what we do, and looking at how we resource issues. And I know for the Chair of Community Services, Councillor Noonan, this has been an issue that she has been very, very focused on, the broader social issues as part of the Community Services program. And the community partnerships team are going to be critical to our role, and I'll certainly be have discussed with Councillor Noonan and be looking for her to play a lead role in how we move this forward. Councillor Laurie.
Thank you, Madam Mayor. That's great, and I agree. My question that started that discussion was, do we have the capacity now in our social services for the people that might be removed from the CBD under this bylaw? Do we have capacity for them to have somewhere to go? and when I
The
say
answer
we,
is,
I mean
the
the
answer
city.
is, I think the answer is yes. Mr. Hammond's saying to you yes. He's,
The answer is currently yes, we do, but they are highlighting that in future there is going to be a need to develop more housing, there's no doubt about that.
Yep,
because
great.
some of the accommodation they're using actually changes hands, gets sold.
Sure. And my last question through the chair is, if we enact this bylaw and we stop people from occupying the CBD overnight, some of those people will not want to be helped. They won't want to go somewhere like the night shelter, wherever. So where will they go?
So through you, Madam Mayor, the bylaw that's attached as attachment 1 constrains the areas that the bylaw applies to. So anywhere outside of those areas is not covered by the bylaw.
Sorry, through the chair, I'd just like to know where staff think the people who are on Trafalgar Street now might go. Would they go to possibly Anzac Park or the Mai Tai, the riverbank? What will be the consequences of this action? That's what I want to find out.
Mr. Hammond may wish to respond to this because we have been doing quite a bit of work around this.
Very briefly, I can speak to one of the gentlemen who I spoke to on Sunday, who is from the Christchurch area. So I spoke to him about the impact on him of the bylaw. He himself wasn't particularly concerned about it because he has other accommodation options and is also intending to return to Christchurch soon. So I think what that highlights is that different people are in different parts of their journey and have different options, and it's not a broad sweeping, it's actually an individual by individual kind of thing.
Thank you. Now I'm going to move on to Councillor Fulton and then we're going to go to Ms Julian.
I have a question regarding through the chair, what the Chief Executive's just talked about. In terms of the recommendation, it says it directs the Chief Executive to prepare an enforcement policy which will include where a person is homeless and sleeping in the city centres rather than sleeping as a form of protest, council officers will work with social agencies to try and find solutions for those persons. Why can't those words be put in the bylaw under section 13?
Ms Barton? Give you a moment to think about that. You may wish to come back. I'm happy if you want to come back on that question.
You, Madam Mayor, I might just seek some advice on that in terms of those that have...
And I'll expand a little bit as to why, because to me that's a great move, but that's right now at this point in time, and this bylaw is going to be around for 5 or 10 years. The recommendations and the resolutions will be lost over a period of time, but if that is the intention of the bylaw, to first of all support and try and help people who are homeless, then I believe those words should be reflected in the bylaw so that when it's reviewed in 5 years' time and in 10 years' time, that is the essence which we are ensuring is retained in there. I think that other parts of the bylaw, there has been a reflection in terms of the protesting part, but the sleeping part still starts out in a place of enforcement rather than a place of compassion. So if the words could be incorporated in, then I would feel a lot happier.
Ms Barton?
So through you, Madam Mayor, the reason that they were included in the recommendation was because that's a policy approach as opposed to a regulatory document. However, what we could do is look to add an explanatory note within the appropriate clause, which would identify that Council's general approach is, and it doesn't then form part of the formal part of the bylaw, but it acknowledges it within the bylaw as an explanatory note.
Thank you. So we're now getting down to some drafting matters, and so what I want to do is not to push those through at this point because we need to hear from Ms Julian. If councillors have got questions about the bylaw itself, then I'd prefer you held those until Ms Julian has run you through. Okay, so now I'm going to invite Ms Julian to join the table, and I'll just ask you to hold your other questions so that you can get all of the information, and then you'll be better able to formulate questions, I think. Ms Julian, welcome. If you can just talk
Thank you,
us
Madam Mayor.
probably reasonably slowly through this process, because it is, I know for many people who are not used to the drafting process, it can be a bit confusing.
One of the first comments I'd like to make is that the draft as it appears on the agenda looks incredibly messy. And that reflects the amount of time and the to and fro of staff, myself, in discussing the submissions and endeavouring to address the concerns of the submissions as fully as we possibly could, while also addressing the problems that the council had identified. So some of the cross-outs will be matters of syntax, punctuation, things like that. I'm not proposing to tell you that we put a comma in instead of a semicolon, unless you would like me to do that. I can go through every single detail. Right,
no.
thank you very much. That would be tedious.
I don't think that would be considered productive.
As indicated, we have been through the bylaw very carefully, taking account of the submissions and the weight of the submissions. That weight as in terms of the quality of the argument as opposed to actual numbers. So sometimes one or two people might have mentioned something and it was deemed to be important. Sometimes it was dozens of people. It's the quality of the argument that was important to us. We have endeavoured to, we've made sure that the bylaw complements the existing provisions, but also addresses the gap that was identified in the problems that you had put out there in the notification documents. And importantly, clause 12 of the notified bylaw has been amended, and I think that was the area of primary concern for most submitters. So, starting at the beginning, perhaps page 24 of your agenda, the administrative clauses of the bylaw couched on that page or commence. The purpose of the bylaw is set out. There are some minor amendments there. Reference to Nelson has been deleted, and clarification is to focus on city centres. And some syntax matters have been addressed in clause 3.16. Then turning to the definitions on page 25, we removed the reference to the chief executive because we don't refer to the chief executive anymore within the bylaw, so the definition was redundant. Commercial services is changed to commercial premises. And then importantly at the bottom of page 25, event has been amended to an organised event, and that reflects the weight of submissions. And we have also excluded application of the New Zealand Defence Force, and the activities of the New Zealand Defence Force is covered by the district plan. Over the page, the nuisance definition has been refined simply to the same definition as Section 29 of the Health Act, and that's a fairly standard provision for most bylaws in New Zealand. Signage changed to sign, it's just wording, and we've removed advertising leaflet or flyer because that's covered in the urban amenities bylaw. Claire has covered the changes in the definition to sleep, so that
through you, Madam Mayor, we can read the revised wording.
Yeah, that would be helpful. Claire, if you got that written.
All right, so this is one of the changes that has been worked through since the agenda was distributed.
So the wording would now be means the occupation of a footpath or road in the city centres. So the words site or space in a public place are deleted, and the remaining wording is retained as contained in that definition. So if you'd like me to read that again, it's sleeping means the occupation of a footpath or road in the city centres, etc.
We'll keep going and then just hold your questions to the end. Thank you.
Right, thank you, Madam Mayor.
We'll hold that question.
window display has been amended to simply refine the syntax of that definition. We then move on to Part 3 of the bylaw, and Part 3 sets out pretty much the standards you would expect to apply in an urban environment. These provisions are a lift from the model bylaw that's provided by Standards New Zealand, and there have been some minor amendments. Clause 8, we've said prior permission of an authorised officer, cause or allow. So there are a number of syntax and refinements through there, specifying that damage should occur, it relates to damage in a public place. So in a public place has been inserted towards the bottom, without prior permission of an authorised officer, people shall not use a footpath. Just some clarification of those provisions. And over the page, we have reduced the width of the footpath that can be taken up from 2 metres to 1.5, and that's simply, it's just a practical change because of the width of the Nelson footpaths. If you say that people can't have to allow 2 metres, then you're taking up most of the footpath anyway, and it just won't work very well. And retained a provision somewhat amended to make sure that emergency services have access to a road if it does, or footpath if it needs to be blocked. These are very practical provisions, and they're found in bylaws right across the country. Clause 8.4 covers the leaving of things on footpaths, placing of things on footpaths, and makes special provision for not-for-profit organisations running a fundraiser. Just checking that I'm reading, because the printout, and I'm sure it's the same for you, the printout starts to get a little faint. Why I need stronger glasses. Moving on to clause 9, veranda lighting. It's a safety matter. And if the council wishes to avail themselves of that provision, then they have some grounds to be able to install veranda lighting at cost. Window displays. One of the concerns that came through with the submissions was how that was going to practically work. We have made some changes in terms of catering to not-for-profit organisations acting in accordance with within this bylaw, and critically there was some concern that we want to leave some space in front of windows so that people can either see what is in a window or navigate. If you're going to a commercial premises and you're not sure whether the office you're looking for is in that premise, usually there are signs on doorways saying who is located. You need to be able to step up to that window. So people felt that maybe 500 millimetres wasn't enough. We've expanded it to 600. It's a very small change. I don't think there are any other particular changes there. And then clause 11 around permissions has been refined and made simpler, I think is the easiest way to describe it. So this is about permissions that the council may wish to grant for use of the road. So it starts off as any use of the road or footpath allowed by this bylaw that does not require permission shall, and then steps through the requirements. So shall allow members of the public to use a public place. And it all sounds rather legal. The most important part of that clause is in 11.2 around where permission is required. The council will need to consider the duration of the activity, its location, whether the activity is compatible with any other approved activities, reasonable safety considerations, impact in relation to noise, odour or any other offensive emission, likelihood of damage to public places, public property, impact of the activity on retail and commercial premises, and that the activity is consistent with the bylaw provisions. And importantly, if permission is not granted, then reasons must be provided to the applicant. So we've endeavoured to address many of the concerns that were raised by submitters. And then...
Can I... There's a bit of noise in the background there, might be just bouncing up this way. It's a bit
Oh, thank you for raising that now, Councillor Skinner. Ms Langley's going to address that now, just ask the members of the public if they could be a little bit quieter. Thank you.
And then in terms of clause 12, this has been heavily amended, in fact replaced by a clause that was particularly requested by over 150 of the submitters. We have, after having some conversations to clarify Wellington City Council's position, we have inserted the Wellington City Council bylaw provision, and the reason that confusion occurred was that they had conflicting information on their website. I had spoken to staff in Wellington City and received one lot of information which I did give to the council last time we met, and I apologise that information was incorrect. Wellington City Council's bylaw and their staff have altered their position, and it now reflects the true nature of their bylaw. And so too, we're proposing exactly the same provisions here. Great that we've had that debate and that we're able to respond to the submissions of so many people. Final provision, sleeping in the city centres. The only change there is that we're not proposing the alternative that has already been discussed with Ms Barton.
So that was a deletion of 13.2.
That's correct.
It's now deleted. Right. Thank you, Ms Julian. Is there anything else you wish to add at this stage, or are you ready to take questions?
I'm ready to take questions.
Thank you. I have Councillor Barker, or happy? Thank you. Councillor Laurie.
Thank you, Madam Mayor. Thank you for that. The bit about not sleeping on the footpath or on the road, does that include benches and public furniture?
Yes, it does.
Through the chair, does that need to be spelt out, do you think, in the bylaw?
It's contained in the Local Government Act.
Councillor Rutledge. Councillor McGurk.
Yes, Madam Mayor, a couple of questions. Is there a given consideration to a definition of a not-for-profit organisation?
Bear with us just for a moment. We think we have considered this matter. We're just going to hunt up the word.
Sorry, I missed that answer, Ms Julian.
They said that they're just looking for a response.
Oh, they're looking for a response. Thank you.
Wait for the response, because I've got a couple more questions.
It's covered in clause 8.4 C 1 and 2. It refers to not-for-profit organisations.
Yeah, it tells me what they can do, but doesn't describe what they are.
I'm happy if you both wish to have some time to think about that. So this
Yeah.
again, we're into now the drafting, and I want you to have some
Yeah.
opportunity to talk to Ms Anderson as well. So I will be making sure we have an adjournment before we go into the final decision making. So you've got any chance to respond on those points. Councillor McGurk, anything further?
Another question, it talks about in 11.26, which I think it is, the impact of activity on retail or commercial premises. And I'm just, in my mind, I'm just wondering about the bargaining provisions if, in terms of, say, an industrial dispute.
The whole tenor of permits has been flipped around so that these matters need to be taken into account. But if a permit is denied, then the council must give some reasons, and those reasons will have to be reasonable under BORA. I can't answer for every possible circumstance that might exist. But the freedom of expression and the right of people to protest in New Zealand is an important part of our law, and I think that it would be most unusual to endeavour to ban someone from picketing their place of work, for example, on those grounds. It's really for the officers to work that through.
Any further questions?
No, I'll let others have an opportunity.
Thank you. Councillor Fulton.
Yes, thank you, through the chair. I have a couple of questions. My first is regarding 10.2.2 on page 29. I just wanted you to clarify to me what your intention of those words are. They don't quite make sense to me. It says, no person shall place items on the footpath such that the signage or window displays of retail or commercial premises in the city centres may only be viewed from a distance of greater than 600 millimetres. So you're saying that somebody has to be able to stand 0.6 of a metre away and see in, or are you saying that area between the window and that area has to be
within that
clear,
space?
Has to be kept clear? It doesn't say that area has to be kept clear. It says that you should be able to be viewing it. When I read that, I am under the impression that you need to be able to stand from 0.6 of a metre back and see into the window, which means you could be looking over things.
So through you, Madam Mayor, we'll note that one and we'll come back.
Okay, and then my next question is around, I think you mentioned Napier, Porirua and Hamilton City at the start. Through the chair, Ms Barton mentioned those three as having words which prohibit sleeping at night in their bylaws. Could you point them out in the agenda where that, I think it's Appendix 4, I can't see those specific words. Are they in our agenda or are they subsequent to the agenda being printed?
So through you, Madam Mayor, they were subsequent to the agenda being printed, which I'd highlighted. I'd done some more work late.
Okay, could I please get a printout of those words to compare to what our bylaw says?
So I have available, we did a trawl through of all of the councils. The specific wording may not be in the spreadsheet that I have, but I can find those.
So it was Napier, Porirua and Hamilton, yeah. And then my third question through the chair is on page 16 of the agenda. It talks about the options to, in terms of moving forward, and it mentions option 5, withdrawal clause 13 regarding sleeping in city centres and the definition of sleep. You talk about the advantage being no legal risk. What is the risk? What is the legal risk of that part being retained in the bylaw?
So through you, Madam Mayor, I'm clarifying whether that's a legal question, in which case it may be better directed.
I think if it's around legal risk, it is a legal question,
Okay.
and so when we go into public
so
excluded, then that's the time for you to ask the questions,
to ask that question.
whether it need legal answers.
It's just it was in the public agenda, so I just wanted to be clear. And then finally, in terms of the changing of the definition of sleep, So you've said means the occupation of a footpath or road in the city centres, but then you've added in, after Councillor Laurie's question, that that would include sleeping on a bench, which is not a public footpath in my mind. So does it also then, if there's areas, so up in Auckland, homeless people are often sleeping in recessed areas. They're not sleeping on the footpath, they're sleeping in front of shop frontages and recessed areas, which I wouldn't define as the footpath. Is that intended that you include those areas?
So through you, Madam Mayor, I'll answer in part, and I might seek some advice from Ms Anderson. If it's in a recessed area that is part of a private property,
Yep.
then that is private property, and it would then be subject to other legislation such as trespass provisions. If it's not within the footprint of the land block ownership, then it would be footpath,
Yeah.
if it provides access.
Thank you. Councillor Delberg, then Councillor Skinner, and then Councillor Laurie.
Yeah, thank you, Madam Mayor. 11.3, page 30, for must be provided to the applicant. Do we need a timeline on that, or is there a general timeline?
Through you, Madam Mayor, we could add the words prior to the event.
Says, okay, I'm just looking at it. It says if permission is not granted for reasons to be provided in the applicant. No. Okay, yeah, prior to the event. Okay.
What I would prefer, Ms Julian and Ms Barton, is that they are drafting questions, and so I'd prefer that you took some time to reflect with legal counsel around that and give a collective response.
Yes.
I think you may find that being able to give answers prior to an event, if it happens 2 hours later, might just challenge any organisation. So you might just have to reflect on that one, so that's another one to come back with. Thank you, Councillor Delberg. Councillor Skinner.
Thank you, Madam Mayor. Couple of questions. A small one, page 31. Just is that a crossing out of camping? It says part 4 of the title, part 4 events and camping. Is that crossed out? Faint.
Through you, Madam Mayor, it should be and sleeping.
So add.
It's clear in the index at the front on page somewhere.
All right, if you could just clarify that for everyone, the page and the clause, Ms
Page.
Julian, so that we all have the same information, please.
Page 23, list of contents. It's been altered there, but that amendment is not translated through to
So that the amendment is to be,
events. It's a heading,
yes,
events and sleeping.
and sleeping. Okay, that's it. What's showing on my version. Is that not on
Seems to have
righty-ho?
come off some.
Okay, thank you. Councillor Skinner.
Thank you for that. Similar to Councillor Fulton, I just found that, had to read it about 11 times, that window displays 10.2.2, to understand, I get what it's trying to say, but the wording's a bit hard to work out before, what's referring to what, this viewing of the displays or the windows or the in front or behind. My more serious question on that is, why not make that distance larger? So it says not greater than 600 mil, why not make it 1.5? What's the methodology for that? Like if I'm viewing a window and I'm quickly scanning what's in there, enjoying it, or trying to find the office to the dentist upstairs, you're standing back a bit rather than sort of pressed.
Through you, Madam Mayor, there's always a balance in these matters, and it's an endeavour to make sure that the footpath remains available for the passing and repassing of pedestrians. That's what the bulk of a footpath is used for, people going back and forth. And so more typically, if somebody wants to have a look at a window display or check which office they're heading to in a commercial building, they will step up relatively close to get out of the way of the pedestrian to and fro. We considered, as you know, the bylaw was notified as 500 mils. it could be expanded. We've expanded it to 600, which is about the width of a standard modern kitchen bench. Yeah, exactly. You've got it. Most people would be able to see something within that space. And of course you don't want to create a bylaw that then has people standing maybe 1.2 metres away in the middle of the to and fro of footpath, thereby creating a blockage as well. It's a balance. So if you would like that changed, then it's a matter for councillors to debate.
Thank you, Councillor. I'm just thinking it through, and it's trying to link it in with the other rules that sort of overlap here. So I'm sort of thinking people could obstruct, affect business or the ambience of the business in front by having stuff just back off 600. I'm sort of thinking I want to have it further back, but then I'm trying to tie it into 8.4 in regards to placing items. So I'm just sort of working from my head, so that sort of stops people leaving items. Do you think that, I'm trying to visualise it as a shopper and a shop owner. Do you think we should give that more space coming back, or do you think the other rules cover that?
We've just had a quick conversation about the other bylaw provisions that Nelson already enjoys, and the balance between that, and we think we've pretty much covered the reasonable use of a footpath, placing of items on the footpath. People do want to place items on the footpath. You know, signs, for example, are covered by the urban amenities bylaw. There might be a fundraising thing, which we've already covered in here. So, you know, we have to balance up all the usual uses of a common space.
Thank you.
Madam Mayor, I'll give it a bit more thought, but what I'm highlighting here is that what we're trying to do is keep businesses thriving, vitality happening, people coming and go, whether it's just making their way to A or B or enjoying the shops. And the feedback over the weeks and months, and especially yesterday from the shops, was that vitality by blockages, regardless of how far or close, even when you're driving by, seeing a bit of an obstruction. That's more than a 600. We're not bad at drive inside the 600, and people are a bit turned off by what's could be nice, appealing, especially as what with the artwork, design, and the loveliness about the boutique ambience of the CBD is that window displays. That's what it's about, changing window displays. If those are blocked even further out than 600mm, my concern is we're back to similar square one. But I'll just give it a thought. I just want to highlight that in our decision making.
All right, I'll let you think about that, and the officers will as well, but this is, as we discussed before, this is a balance about allowing public enjoyment by all. So this is about the types of activities that go on within cities and that importance of that trading zone. But reflect on that, and the officers will as well. Thank you, Councillor Skinner. Councillor Laurie.
Thank you, Madam Mayor. Through you, under this bylaw, would you be able to, as of right, park a bicycle up against the front of a shop or a building in the CBD?
Through you, Madam Mayor, technically it would be an obstruction. Most people wouldn't park their bike against a shop window for a great length of time, and most people, sadly, in these days want to padlock their bikes, and they would not be doing that. The bylaw cannot address every possible incidence of unusual behaviour.
Through the chair, what about just a building that's not necessarily a shop?
The bylaw covers the city centres, so that would cover whatever buildings are within the city centre's definition.
Right, so you wouldn't be able to park a bicycle anymore in front of a cafe?
Technically, it would be in breach of the bylaw unless there's a space provided by the council so to do.
Okay, next question through the chair. How long would you need to be in a space before you are deemed to be occupying it?
So through you, Madam Mayor, those questions are around reasonableness, which is a matter that the enforcement officers look at on a case-by-case basis. So if the bike hypothetically had been parked there for 3 days,
Oh, sure.
that may not be reasonable.
Yep.
However, if the bike had been parked there for 2 hours, I think that that would be reasonable. So the conversation may very well go along the lines of, how long are you leaving it there? Can you move it on when you're
Sure.
done?
Actually, through the chair, I'd moved on from bicycles, and I was thinking about people. How long?
That's
how
all
long
right,
could-
Councillor Laurie, but the purpose of asking questions is not just for your benefit, it's for everyone's, and the answers are too. And so we enjoy being able to hear that answer
Oh, yeah,
from
yeah.
Ms
I
Barton.
enjoyed hearing it too.
Good.
But
Thank you.
when it comes to people, for example, how long could someone sit on a park bench before they were deemed to be in breach of the bylaw?
So through you, Madam Mayor, sitting on a park bench at night time, because the sleeping provisions are at night time, not during the day, does not constitute sleeping in terms of the definition that's proposed in the bylaw.
Because you're sitting up.
That's correct, and you're awake.
Okay, thanks.
All right. Just in terms of the questions that are being asked, and I know that I can see Ms Anderson listening and writing as well, just all of these questions, when we take our break, I just want the team to make sure that you've gone through those again and really thought about the questions and the answers, and then when you come back, you'll come back with a comprehensive response to the items. Any further questions before we move on? Councillor Courtney and then Councillor Ackland.
Thank you, Your Worship. Officer Barton, thank you for taking my questions at 9:15 last night and responding. I appreciate that. One of the questions that came through, I think it was part of the email trail, was Councillor Fulton's, which I'd like to, before we get too far ahead of ourselves, and ask, the existing urban environments bylaw, why did we not use that? Because you said you've listed on page 12 here all the options that you considered. But when I looked through that late last night, I thought, well, it could fit quite comfortably within that. This bylaw could possibly have fitted within that existing bylaw, really.
So through you, Madam Mayor, you could have amended the urban environments bylaw to capture the components that are proposed now through the city amenity bylaw. That does raise an issue of then whether the remainder of the urban environments bylaw might then be open for public input. And it was felt that the problems were defined, and therefore we'll have a specific bylaw that deals with those problems.
Councillor Ackland.
Mine's just around the drafting of the definitions of clause 13.1, the sleep definition in clause 13.1. But I think I can probably address that when we go into legal, just on, it seems double up on the definition. It says the definition is actually defining the action that's wanting to be taken by the regulation. But anyway, we can talk about that probably.
Okay, we'll pause that one and we'll make sure we cover that off. Anything else at this stage? Or are we happy to move on? All right, councillors, we need to now, you've got some questions that you've signalled that are questions where you need some legal responses, and so we'll use our normal process. So for the public, the matters that we deal with in public excluded. Now, I have been asked by the administration or governance advisors whether we do have a room next door which is Ruma Marama, which is quite a large room, and so the governance advisors have sort of looked at how many people are here and gone, no, actually that room would work. Are you comfortable to move to it? Would that be possible? Just the advantage of us staying here is that all of our technology is set up. If that's going to be a problem for people, then we'll move. But I think that would be a reasonable request. Thank you. And we're just going to move into public excluded. Oh, and we just need to now, in order to do this, and we do this in public, we need to move the resolution to allow Ms Anderson and Ms Julian to remain. And we need to move to exclude the public with the normal clauses in the Act. And the reason for that is legal professional privilege. It's so moved by Councillor Barker, seconded by Councillor Rutledge. I will put the motion. All those in favour? Aye. Against? Carried. Thank you.
Through you, Madam Mayor, can I
them in a moment because it's a public matter. They may need a little bit longer than that. I think 3/4 of an hour would be better. I don't want them pushed, but we'll see. All right, we're now back in public. So my apologies, I didn't realise we were back on live streaming. Thank you, EJ. I wasn't aware of that, so apologies for my mumbles. Councillors, I'll just ask you all to take your seats and then I'll commence the public session. Thank you. All right, thank you. We're just resuming back in public. We've now had, thank you for your patience, members of the public who have been here today, to allow us to be able to ask legal questions and receive those answers. We have had the explanation of the run-through of the officer's report, the tabled recommendation today, the bylaw as proposed. There have been a series of questions asked throughout our public session in regard to some of the drafting in relation to that bylaw. The officers need to think about how they wish to respond to those questions, and I'll hand back to Ms. Barton to inquire, are there matters that you wish to go and look at further? If you could identify which ones you have you wish to cover, just to make sure that we've got them all, and then I'll be asking you for an indication of how long you'd like to go away and work with the team on those.
Thank you, Madam Mayor. So in terms of the issues that I've taken from discussions this morning, we will be going away to look at the definition of sleep and its relationship to the relevant clause within the bylaw. We will be considering clause 10.2.2, which relates to the distance that's specified in front of a window and whether that needs refining. We will be looking at clause 11.3, which relates to permissions, and in particular whether we need to define when we would be giving notice back to the applicant. So whether there needs to be some time frame around that. We will be looking at the definitions of footpath and road to see whether the issue of street furniture needs to be incorporated. And in addition, looking at whether there needs to be a definition around darkness or nighttime. And in addition, the not-for-profit definition as well. Sorry.
Thank you. Councillors, are there any other matters that you recall that you wish to have considered in the drafting? I think there was an explanatory note. Ms. Barton, did you capture the explanatory note? I think that was the one Councillor Fulton was going to signal.
Through you, Madam Mayor, yes, sorry, I missed that one. Explanatory note with regard to the policy that's addressed in the recommendation.
Right, thank you. Anything else? I can't recall anything. Councillor Fulton?
Yes, and I also asked to see copies of the Napier, Porirua and Hamilton City wordings for their...
Before you make your, go into your decision making. All right, so it will be important that everybody has that information, or it's in a place where we can all access it. Since we're here, that might be the easiest thing to do. So Ms. Barton, if you've got some spreadsheets and you could perhaps make them available to us in Ruma Marama, that's probably better than the Councillors' Lounge. That would be useful. Thank you.
Thank you, Madam Mayor. And also, we expect that we'll need about 30 minutes to wrap this up in an ideal world, hopefully.
All right.
And the other part of that is that, you know, during that process, you may wish to consider the reasons that will be formulate part of the bylaw.
All right. And just as in relation to that, you have you've given us some suggestions in your officer's report, and could you just remind us what page that is on, please?
So through you, Madam Mayor, it was paragraphs 7.4, which is on page 17, through to 7.8, which is on page 18.
7.4 to 7.8. Thank you very much. So we just need to, we can do that in the break and have a read through those. Now, Council, what I would say to you now, to assist me as chair and to assist the officers, if anyone was planning on moving amendments to what has been moved and seconded, now would be the time for you to signal that, because that would require then further work for the officers to consider that. So if anyone is planning on moving an amendment, now's the time for them to tell us. No? So there's no amendments. Councillor Fulton?
It is, it's my preference to still use attachment 1A with those alterations. I do believe that the sleeping part of this bylaw is a step too far in terms of the freedom of the Bill of Rights Act, and so it's my preference to move that everything else I'm happy with. The amendments to the bylaw shown in attachment 1A.
All right, so
I might not have anyone who will second
Do you
that.
wish to move that?
Yes.
All right, because we'll do that now so we know what we're doing. I'll call for a seconder. There's no seconder, therefore it lapses. Thank you, Councillor Fulton. All right, now we're going to adjourn for a period to allow the officers to consider their drafting. We will need to see any changes on the screen, so you're going to need to work with the governance advisors to make sure they're available, and we'll be looking for the spreadsheet around the other bylaws to be available in the other room. When we come back, we will still need to just receive the minutes, so we'll just have a few things to do in relation to that. So you're seeking a half an hour adjournment. Shall we make that 11:45, and then we'll be back here? All right, thank you very much. I'll adjourn till 11:45. right, we're resuming the meeting. Thank you for your patience, and obviously that's taken a little bit longer because we had a fire alarm in the middle of that, which has had us all exit the building, but we're now back and everyone is safe, and I believe everything is in order in the building. Ms. Barton, you went away with the team to look at drafting matters, and you've come back to us, and councillors, you will have tabled some proposed amendments in relation to drafting, and Ms. Barton will run through those in a moment. I'm just conscious that we are yet to receive the minutes that were tabled this morning. So the minutes have moved by Councillor Noonan as a true and correct record, seconded by Councillor Walker. Are there any amendments that people are seeking? Happy with those? Councillor Barker?
Not an amendment, just really a comment, and I sympathise with the problem that the staff have had with the sickness, but I would like to have seen, if we have comments about some submitters have said, you know, we should be consistent and have as many as possible of the reason for these comments, rather than just having some and saying the words were, for many of them, presented to submission or something like that. It was, I can't remember what they were now, but when I read it last night or this morning, I thought it's better if you have all of the comments that people make rather than just having a few. But I'm quite happy under the circumstances for them to go through.
Well, I'll just perhaps, in terms of the rationale for the minutes, I will just defer to our governance advisor. Yes. So the thing to remember is that if it's in the written submission, it doesn't get repeated in the minutes with the verbal submission. So if the points have all been made in the written submission, that stands as the official, that's the record, it's part of the documents. So what we record is the additional points that are made in the verbal submissions. It's been moved and seconded. I'm going to put the motion. All those in favour? Aye. Against? Carried. So that's the minutes have now been received. And now I'll hand over to Ms. Barton to talk us through the document that has been tabled. Does everybody have a copy? Yes, Ms. Barton, when you're ready.
Thank you, Madam Mayor, and I might also rely on the two either side of me just in case I miss anything in particular, but I will walk you through the proposed changes to the recommendations, and I will then, at the end of walking through the changes that we're proposing or recommending, the provisions that you had asked us to look at and consider that haven't been included in the recommendations, the rationale as to why they haven't been included. So I look at the recommendation pages in front of you. I'll run through those bullet points at the middle of the page. So delete clause 13.2 was as we discussed earlier on this morning, and that's the other clause that sits within the sleeping provisions. The second bullet point is about replacing clause 10.22. So clause 10.22 relates to the placement of items on the footpath, and as currently worded, it talks about placing items on the footpath such that the signage or window displays of retail or commercial premises in the city centres may only be viewed from a distance of greater than 600 millimetres. And there was a question around whether that was easy to interpret, and I think for clarification purposes we're proposing to amend it to read place items on the footpath within 600 millimetres of the frontage of retail and commercial premises in the city centres. There's some other pre-clause to that which gives it the context.
Ms. Barton, I'm going to take questions as we go on each one. Yep. Councillor Delberg.
Yeah, thank you, Madam Mayor, through you. So what if I'm a retailer and I've got my sign sitting right by the window, you know, obviously they want to, otherwise the other choice is they're over by the gutter, and the feedback is that sometimes clutters it for people in, you know, wheelchairs and
Ms.
things.
Barton?
So through you, Madam Mayor, the issue of sandwich boards was traversed through the Urban Environments Bylaw, so that bylaw specifically provides for sandwich boards, so that doesn't impinge on those provisions. This doesn't impinge on those provisions.
We'll continue on.
Okay. So the third bullet point We're recommending to delete the sleep definition. So there was a question raised as to whether it was necessary to include a definition, given that the only reference to sleep is within clause 13.1. And we've reflected on that and think that we can incorporate the appropriate wording that was in the definition within the actual clause. So the wording that's now proposed is that no person shall sleep or otherwise occupy a footpath or road in the city centres unless permitted to do so by an authorised officer during the hours of darkness. Now, darkness was another issue that was raised this morning, and we have now clarified, I'll put some context around that within the clause. So the wording proposed is being a period of time between half an hour after sunset in one day and half an hour before sunrise in the next day for a period of 2 or more continuous hours. Now, that definition of darkness is exactly the same wording that's currently contained within the Urban Environments Bylaw. The fifth bullet point, we're proposing that within both the definition of footpath and the definition of road, so both definitions, that the following wording be included, and includes any structure fixed to the footpath or the road, depending on which definition it sits within. And that was in regard to the questions asked about whether street furniture, for example, may be included in that or not. The last bullet point on that page, this I had mentioned earlier, is just an error that needs fixing up to keep the index, which does say events and sleeping, consistent with the actual heading that's in the bylaw. And then the final proposed change is to add an explanatory note into clause 13.1. So 13.1 is the sleeping provision, and it notes any future enforcement policy will include a provision that where a person is homeless and sleeping in the city centres rather than sleeping as a form of protest, council officers will work with social agencies to try to find solutions for those persons as a first response. So noting that that is an explanatory note rather than forming part of the bylaw as a whole. And the other amended, so that wording change that I've just gone through is also reflected in the adoption clause. So it's exactly the same wording in the adoption clause that's sitting further down that second page. And then I just would alert you to another change, which is highlighted in yellow in the third paragraph on that second page, that there's a proposed recommendation adopts the reasons set out in the deliberations report in paragraphs 7.4 to 7.8, subject to the amendments to attachment 1 identified in these resolutions. So that's the changes that we're recommending. If, through you, Madam Mayor, with your leave, I'll just touch upon the other aspects that were raised earlier and the reasoning why.
Right. Thank you, Ms. Barton. What I will say to councillors, I'm going to take you through the deliberations report on paragraph 7.4 to 7.8 shortly, just to confirm those reasons. Ms. Barton.
So through you, Madam Mayor, just bear with me because I have to just make sure I've covered off everything in here. So not that one. There was a suggestion that clause 11.3, and 11.3 relates to permits and timing, and whether in terms of a response from council there needed to be some time frame put around that. We're not proposing to put a time frame around it. Council officers always endeavour to work as speedily as they can, but given the context of not knowing when somebody may be coming in, I think it's incredibly difficult to prescribe a time.
Question from Councillor Barker.
Oh, yeah.
I wonder if you considered that the time could be prior to the time of the proposed commencement of the event.
So through you, Madam Mayor, we did consider that. However, if we were only to be notified an hour before the event, it may be that nobody is actually physically available to consider that. So there are issues that we have considered, and we think it would be
I just think in other terms it would be good manners to tell people you can't do it before the time it was scheduled.
And I think that as part of the communications that we can put around this, particularly on the website, it will be about you know, if you are in the position of needing to notify the council, please do so as soon as you can, and that we will work with you to give you a response within a timely manner. So we can put some comms around that. Okay?
Deputy Mayor?
Yeah, just on that point, it might be, see if this is helpful. Why don't we have something like we will respond within 5 or 7 days on receipt of the information, on receipt of the application?
So through you, Madam Mayor, in an ideal world that would be fantastic, but it may be we only get notice 2 days prior. So
Yeah, well, it also, wouldn't it also, through you, Madam, wouldn't it also warn them that they need to give that time?
So we would then need to go into refining the definition or the provisions to actually say you must then provide us with the notification 2 weeks prior.
We're making it
and
complicated.
that raises some complications.
I would say to Council also, as the mover and seconder, Councillor Rutledge and I have reviewed this, and we're prepared to, as mover and seconder, amend our motion to allow for what the officers are recommending. Ms. Barton?
And through you, Madam Mayor, the final, actually two, the second to last, was the definition around not-for-profit. We have considered that, and we think that it's standard practice in terms of understanding what not-for-profit is, and we don't consider it's necessary to define it. And the final request was for copies of the relevant provisions out of the 3 bylaws that I cited this morning, which were the Napier, Hamilton and Pororua bylaws, and they have been tabled.
All right. Any questions from councillors before we move to looking at the clauses 7.4 to 7.8? No questions? Just see, EJ, procedurally, do we need to note now in the minutes that the mover and seconder are happy with the changes? We've done that. Right, we've done that. So, councillors, I'll now take you to starting on page 17 through to page 18, and at that point, the paragraphs there identify the reasons as set out in the deliberations report. Are there any reasons that you don't agree with, or are there any reasons that you believe should be specifically noted in addition to what is there? Nothing? Nothing further? All right, do we have any final questions for Ms. Julian, Ms. Barton and Ms. Anderson before we move into deliberations? Councillor Fulton?
Yes, I raised a question during the workshop last week around the enforcement policy with regards to the removal of things and what would happen to those things, whether they would be placed in safekeeping. What is the best way of ensuring that that is delivered, and is it worth noting it in the recommendation, or?
Through you, Madam Mayor, would you like me to answer that question?
Yes, please, Ms. Anderson.
There is a specific procedure set out in the Local Government Act 2002 about how you go about seizing things in contravention of a bylaw. It sets out notice requirements, how you look after them, how they get returned, so it's set out in statute.
So is it possible to refer to that in the bylaw as a note, or is it possible?
I think in the discussion with the officers that's part of the that's part of the communications.
Yes, that's
around
correct.
This.
We can put some communications around that on the website, and because it's in statute, we don't need to refer to it in here.
All right. Any further questions? In that case, thank you very much, Ms. Barton, for the work that's gone into preparing this bylaw and for the very careful consideration that you have undertaken in relation to the submissions process. There's been some absolute diligence across this in terms of reflecting the views of the community and bringing forward the recommendation. I want to thank Ms. Julian and Ms. Anderson for the work that you've done as well to bring this forward to us. I also, Ms. Julian, thank you for your apology earlier in relation to the Wellington scenario. That wasn't, I'm sure, what you were expecting when you made your inquiries, and it came as a surprise. So it certainly helped explain to some of us sitting around the table why we felt that that wasn't quite fitting as we thought it should, but now we have the understanding, so thank you. Yeah. Councillors, we've moved and seconded, so I'm now going to open the floor to speak to the motion. I would just say in opening that, as I said earlier, there are a complex set of issues that face communities all around New Zealand. We have a bylaw process now that I think that is aimed to enhance the functioning of our city centres and aimed to enhance the functioning to ensure that it is for the enjoyment of all, because that is what public places are about. I'm satisfied with the provisions that are there. But as I said when we were at the start of this deliberations process today, there are some bigger social issues that are facing communities all around New Zealand. We're not alone in this. The issue of homelessness is one that is multifaceted. But I have a very strong view, as I said earlier on, that homelessness in any form or for any reason is not the best outcome for Nelson citizens, for their health and their safety or their wider well-being. But I'm also old enough to know and interact enough with the public to know that for some people that is a choice. That is a way they choose to live, and we will make sure that the services are there, and Mr Hammond will work up with our other agencies across Nelson and central government agencies, volunteer organisation, to make sure that we are a caring and compassionate city, because that is important. If we live in a city, we all have responsibilities as citizens, and in my view it is our responsibility to be caring, compassionate. A bylaw is part of our responses, and because we do have regulatory responses as a council, but it's by no means the only thing that we do with our community. Much of what we do is not regulatory. Much of what we do is social, and I think we need to reinforce that with our community and with our government, to say that actually local government has a role when it comes to social wellbeing, and this council will continue to play its role, and I look forward to the initiatives that we will work on. And I know that for the Chair of Community Services and for the Deputy Chair of Community Services, they are absolutely committed to an approach that builds partnerships with our community, that leads this to being, as it needs to be, a kind and caring community. So I'm very happy to support where we've got to today, and I'll open the floor now to speak to the motion. Councillor Noonan.
Thank you, Madam Mayor. Yes, I support this this bylaw going through. It's been as thorough as is possible. We've taken great care. The officers have been thorough. They've been open. They've been very helpful to our process, and it's very important that we get it right. I trust it will provide a balance for all our citizens by providing enough freedom to protest, but allowing day-to-day transactions to take place. And I think we've come to a good landing point, and I'm hopeful that it will be a smooth ride from here on.
Thank you, Councillor Noonan. Councillor Delberg.
Yeah, thank you, Madam Mayor. Yeah, look, I'm comfortable that it covers the perceived problem. I think it covers off the health and safety issues for protesters, homeless and the general public. I'm comfortable that we cover the rights of our retailers to trade effectively in their premises. And I think it covers off the rights of our residents and visitors to enjoy our city centre. I think there's always going to be some level of legal risk, and I think this has been reviewed and reduced to an acceptable level for myself, provided by advisors. I think variations of our legal obligations, and we're given a due consideration, and I will be supporting this.
Deputy Mayor.
Yeah, just briefly, Madam Chair, I totally support this, but I also want to echo your comments. In the many years that I've sat around here, I have to say that the advice that we've received on this very, very difficult bylaw has been excellent. It's been engaging from our team, and I want to thank you, the whole three of you, very, very much for giving us the right advice and giving us a pathway which we're all comfortable with, and I congratulate you for that. And I'm really pleased just to endorse that word that you did. This is an issue that has not been easy for anyone. When you start respecting everybody's views, you have to find a balance, and you have to be secure for all. And I think what we've ended up with is, with due diligence, a bylaw that is going to, I think, be respected by all parties. So well done.
Anyone else wish to speak? Councillor Skinner.
Thank you,
Councillor
Madam Mayor.
Fulton.
Not much I can add here, but I appreciate how much this has come down to a far simpler bylaw than what it could have been. And this something is not there to undermine common sense or courtesy or reasonableness. That is the public need also taking responsibility and being empowered and taking responsibility to the CBD, which they have the majority. And it's also good to see the majority of councillors here today to make sure this goes through well and well thrashed out and well discussed.
Thank you. Councillor Barker. Oh, apologies, yes, Councillor Barker was next on my list, and Councillor Fulton.
Thank you. Simply just to say, I believe the public of Nelson will be very appreciative of what's been done, although they won't appreciate the pathway that has had to be taken to get here. And this last stage of the process has been very, very well handled by the team behind me, and I appreciate that, and I hope that the people of Nelson will appreciate.
Councillor Fulton.
I'd like to request that the recommendation is put in parts, because there's parts of this which I can support and there's parts of it which I will be debating against. I believe that
Let's just deal with the procedural issue that you've raised first, which, as you know, and you've asked me about this, I'm very reluctant to take this in parts. A bylaw sits as a complete suite of matters, and I have said I'm very reluctant. Is if you could identify the particular part that you felt could be taken on its own, I might consider that, but my preliminary view is quite strongly that we should deal with this in one.
So, in response, Madam Mayor, the first part, the second part, and the third part and the fourth part don't actually refer to the bylaw, they refer to the amendments of the bylaw rather than actually adopting the bylaw, and they refer to the enforcement policies around the bylaw. So they aren't referring to whether, in my mind, they refer to the stuff surrounding it rather than the bylaw itself.
All right. I would say to you, I've heard your rationale, and no, I won't accept that it's taken in parts, because in my view the enforcement policy doesn't exist unless there is a bylaw. So that would be my view, that it sits together. So we'll see it as
Absolutely.
one.
However, the enforcement.
So I've brought, no, what I'm telling you as chair, I'm not going to take it in
so
parts.
I'll just carry on with my debate.
Thank you.
So for me, the first part, the second part of this recommendation is really important, that the Chief Executive is going to ensure that enforcement policies consider people who are homeless and work with social agencies to try and find solutions for these people. And I absolutely support that, and I would like to be able to vote in support of that. To me, that is beyond the bylaw itself. The bylaw has come to us in as two options, option 1 and option 1A, and I supported option 1A, sorry. I cannot, unfortunately, support part 13 of this bylaw, which refers to sleeping on the streets. And I'll just talk through my reasons why. So that is the only part of the recommendation which I believe I can't support. And because that is in the bylaw, I also do not agree that the amendment is consistent with the New Zealand Bill of Rights Act. So there's only two parts in the suite which I do not support. And my reason for this is that when I look at this and I look at whether the impingement is and the restrictions are reasonable, I feel that it is not reasonable to impinge to that degree on people's basic rights, their basic right to be able to be on the street at night if that's where they have to be. I think that for whatever reason, somebody might end up needing to sleep on the street at night, and even though we are looking at all these other solutions to address that issue, that is a person's fundamental right in my mind. And so for that reason, I don't believe the amendments are consistent with New Zealand Bill of Rights Act. I think that there's some other parts of the bylaw which I have concerns around, particularly around the accumulation of people's things. And again, we're looking at a group of people who those things might be all that they have left in their lives. And again, is that their right to be able to have some of these things with them, present with them? We're working with groups of people who have mental health issues, addiction issues, physical health issues, all sorts of reasons why people might end up feeling very isolated and vulnerable and living on the fringe of society. And our role as a council is to take care of all members who live in our society, not just those who have enough stuff to not be living on the street. So in my mind, we need to be protecting the rights of those people. If they lose their things, they do not have the financial ability to sue or take counsel to court. They probably don't have the financial ability to even fight to have their rights heard through the court system. I also believe that it is a person's right to peacefully assemble and protest through the night if that is what they choose to do. So there's only one part of the bylaw which I guess I strongly object to in that regards. I understand why it's come about and that we're trying to meet the needs of all people living in our society, but I think that it's just a step too far and I can't support that. I think in closing, my daughters and I watched this movie Chocolat, which came out many years ago recently, and it's about some gypsies who come to town. I'm sure all of you have seen it, and the city actively alienates these people because they're different. And I want to live in a society where we actively encourage tolerance and inclusion. And unfortunately, sometimes even though the bylaw is being created with the best intentions, what can happen is that we end up excluding those who are our most vulnerable more and more as a result of these kinds of rules. And we had quite a lot of submissions about that in terms of urban cleansing. I remember there was, for quite a few decades, there was a move to put little structures on park benches to stop people sleeping on a bench, and then there was a decision that part of our SIPTED rules was that we actually make the benches wide enough and long enough that people can sleep on a bench if that's the only choice they have. So for me, this is sort of a swing back to actually saying, no, we won't let people sleep on park benches anymore in our city environments, and I don't think that's the right direction to be heading.
Councillor Courtney.
Thank you, Your Worship. I'm going to support this bylaw that's before us. Our officers have worked incredibly hard on this, particularly Officer Barton. I certainly admire that woman and the amount of time she's put in. And to think that they've listened to the submitters and taken into account so much of what the submitters have said. You know, one change was the views of 150 submitters, and that really, really pleased me. But you know what I appreciated most of all was your opening remarks when you said you were going to, out of this, was going to come a mayoral summit. And that really moved me because homelessness and having a mayoral summit on that, I think, is a major step forward. Shattered to learn that there's 100 people, faceless people in Nelson, who are homeless. Absolutely shattered by that. And we do have a responsibility. Housing is a basic human right. Nothing provides the individual, the family, and the community with a greater security than a home. So it's imperative that you do move forward with the mayoral summit, and I congratulate you on that. This is a sorry saga. It's been going on for over 6 years. It's not really the makings of this council. I don't want to blame anyone else, but it's not really, you know. One of the people that is in the street, you know, was, and in a position where he had all his possessions taken away, his 2 carts, all his camping gear, his horse, and has nowhere else to go. But if we look at this compassionately and appreciate that and get alongside those people that find themselves in that position, I think we can all hold our heads up high. Now, I think the bylaw goes and is everything that we asked our officers to bring before us, even more than we asked and better than we asked. So I'm very happy to support it, but I just want to say that you've got to look at these homeless people in this way, that each and every one of us could be only 2 or 3 events away in our lives from being in the same position. There, but for the grace of God, go I. In other words, it could be you, Councillor McGurk, Fulton, that find ourselves in that position just through a couple of serious events in our lives, 3 possibly, and we could be there too. So you've got to look at it in that way, and I'm just so delighted with the attitude of this council to think I'm a part of a council that does have a heart, and to include this part of it in this additive here about the chief executive prepared to enforce a policy which includes where a person is homeless and sleeping on the city centres rather than sleeping in a formal place, that they will be taken care of. And I think it's absolutely fantastic, and I'm pleased to support this, and I know the people of Nelson will be delighted too.
Thank you, Councillor Courtney. Councillor McGurk.
Thank you, Madam Mayor. I'll sort of keep my remarks relatively brief, but I too will speak in support of this. This whole process has actually caused me a great deal of discomfort, because I've had to sort of confront some issues that of intolerance, homelessness, the right to protest, and people whose lives are very different from our own experience. I acknowledge the work that the officers have done and the work of this council to get to where we've got. It has required a lot of negotiation and thought and reflection. But I think the result that we've come up with strikes a balance between those intrinsic rights we all have, but balanced against the needs of the wider community. We're dealing with issues of, I suppose there could be someone out there that doesn't cause any offence and doesn't cause any person to be upset, a Ned Flanders type character, I guess. But there are a lot of things in life that do annoy us. There's clipboard bearing petitioners, there's street preachers extolling their particular beliefs, and there will be people who hold particularly strong views, but that's the nature of the community that we live in. So what we're dealing with is the misuse of public space. People that are being obstructive and inconsiderate occupation of spaces there to the detriment of perhaps the wider interests of the wider community. And I do not think that the threat of litigation should be a reason not to do anything. We need to have done something, and something we have done. So for those reasons, I'm heartened that we're actually dealing with issues that are deeper and wider and affect a lot more people in a more constructive way than just legislating it. We won't legislate these issues out of the way. We are dealing with issues that of obstructive and inconsiderate behaviour in our public spaces to the detriment of the wider community, and for those reasons I'll support it. Thank you.
Does anyone else wish to speak before I use the right of reply? No, in that case I will just use the right of reply briefly. Councillors, you heard my angst at the start of the deliberations process, and it's recorded in your minutes about the issues that I was having to grapple with in terms of the type of city I want us to live in. And one of the reasons I live in Nelson is because I like it to be a bit quirky, and I like it to be embracing of difference, and I think that's a good thing. And what I would say to you is that through this urban amenity bylaw, for the first time I'm able as mayor, instead of being able to say as mayor, organisation, I'd like us to respond on some of these social issues, organisation, I'd like us to get involved. And I've had some good support through the organisation. But with a council decision today and with an acting chief executive and a council team who are really saying, yep, actually, we're part of this, of making this a caring community. Actually, through this process, we make a major step forward. And I have to tell you as Mayor, it is very empowering, it is pleasing, it is the right step forward. So for out of some real difficulties and out of a situation that you as councillors, as me as Mayor, has been confronted with, one that we inherited and some real challenges, actually I think we've got a very, very positive outcome. And I have to say that I can't agree with Councillor Fulton with regard to what this delivers is a sign of lack of tolerance, of using a very emotive, clickbait term like urban cleansing, because actually that's not what's happening. What we had before was a council that wasn't engaging on these issues. Now what we have is a council that is engaging, and that's a major step forward. So thank you. I'm going to call for a division on this vote. So I'll put it now. Thank you.
Councillor Ackland. Councillor Barker.
Aye.
Councillor Courtney.
Aye.
Councillor Darboy.
Aye.
Councillor Fulton. Councillor McGurk.
Aye.
Councillor Matheson.
Aye.
Councillor Noonan. Councillor Rutledge.
Aye.
Councillor Skinner.
Aye.
Councillor Walker. Your Worship.
Aye.
The ayes have it.
Hand it over and got to carry it yet. Thank you. The vote is 11 votes for, 1 against, and 1 absence. So the vote is an apology. So apology from Councillor Laurie. It is carried. Thank you. So, that concludes the business for today, and again I just want to thank all of you for being here. I want to thank the public for engaging in the bylaw process and the comprehensive submissions that we received. They have been useful. I think we've ended up with a better bylaw than what we started with, and again thank you to all of the team that's worked on this. I'll close the meeting.